When an agreement is discovered to be void or a contract becomes void, any person who received any advantage under such agreement or contract is bound to restore it or to make compensation for it to the person from whom he received it. Now we are talking of two situations in section 65. First situation, the agreement is discovered to be void. What are the situations in which an agreement is discovered to be void? Is there any difference between saying that the agreement is void or that the agreement is discovered to be void? Because this is for the first time that we are coming across this phrase discovered to be void. In all our earlier sections, we were coming across the phrase the agreement is void. For example, an agreement is void under section 56 if the promised act is impossible to do. That is one section. And yes, Manisha is right. When there is a mistake of fact essential to the contract by both the parties, then the contract is void because of section 20. Similarly, I am telling you the various situations when the contract is void. To start with, a contract is void or an agreement is void which is made by a party which is not competent. That is under section 11. Then under section 20, when mistake of fact by both the parties is there. Then under section 22, when under section 21, when there is a mistake of foreign law made by both parties, then also the agreement is void. Then under section 26, 27, 28, 29 and 30, all those agreements are void. Under section 23, an agreement with unlawful consideration is void. An agreement with unlawful object is void. Under section 25, an agreement which lacks consideration is also void. Under section 36, a contingent agreement where the contingency is impossible to happen, that also is void. So we have various provisions where an agreement is declared to be void. Section 11, section 20, 21, 23, 25, 26, 27, 28, 29, 30, 36, 56. But everywhere the phrase used is that an agreement is void. For the first time we are hearing this phrase, agreement is discovered to be void.